Greetings and welcome back to Criminal Justice 315. Today we're talking Chapter 6. We're talking about witnesses. This is the stuff that you see on TV and you see an attorney just rip into a witness. And this is, honestly, biggest example I can think of, not just Law and Order. I'm thinking A Few Good Men. Talking about Tom Cruise. He's cross-examining Jack Nicholson and he's asking, I just want the truth. Of course, Jack Nicholson says, you can't handle the truth, right? Now, you may say he's not cross-examining because he called Jack Nicholson. That is correct. He's an adverse witness, though. So it's considered more of a cross-examination because he's an adverse witness, right? He's going against whatever Tom Cruise was fighting for, which is, for his client and that he was following orders. But that's why he's more of a cross-examination. But that's a really good example. Just that scenario right there. That whole scenario is what this chapter is about. That's what I want you to understand. And we're going to talk about that. We'll use that scenario throughout this lecture so that we can put these practical examples together and that you, as a criminal justice professional, will be able to understand these concepts to a level so that when you're gathering this type of evidence for an attorney to use in the future, you'll be able to understand how you can get this information, what to look for, and how you can describe this evidence, explain this evidence, its purpose, how it's useful to a prosecutor. So the first thing your book goes in talking about is competency. Competency meaning, in general, it sort of just means like, are you competent? Like, are you a normal human being? That's maybe what it is at a very general level. It goes a little more specific to that because it goes to things like, do you have personal knowledge? If you have personal knowledge, you have competency, essentially. What I really want you to understand, not what competency is, but what is not competency. What is not considered as part of competency. One of the big things that's not considered part of competency is whether or not the person's drunk on the stand. Because if they can testify and give a narrative, the mere fact that they're drunk doesn't matter. I mean, that seems really weird. Now, I'm sure if I'm a defense attorney or if I'm a prosecutor, I'm going to cross-examine that witness about whether or not they're drunk, and the jury's going to hear that. Now, there's some arguments that can be made by the other side if I'm cross-examining about that, but it goes to competency. So that's all I'm trying to do. That's what I would argue with the judge. It's going to be heard one way or another if that person's drunk on the stand. But what I want you to understand is it's not a consideration. If the person can give a narrative and talk about from personal knowledge, they're competent. Age is another thing, too. It doesn't matter how old the person is. Again, whether or not they can testify to personal knowledge. The only requirement that really goes into competency other than personal knowledge of the event you're giving, you're going to give your testimony about is whether or not you can take an oath. An oath or affirmation, because some people are not religious people, they're not spiritual, so they don't put their hand on the Bible, or maybe they don't believe in the Bible, they believe in something else. As long as they can give an affirmation in some way that shows that they understand the importance of telling the truth, how important it is. If they can do that and they agree that they understand they're testifying under oath or under affirmation and that the penalty for lying and not telling the truth is a possible jail sentence, if they can understand that and they agree to testify subject to those terms and conditions, we're going to let them testify. So those are really the only two things that an attorney is going to be considering. So when you're gathering evidence and you know that this person's a drunk, don't let that deter you away from interviewing that person and determining what they know. Because if they have personal knowledge and they can tell the truth and they're going to tell the truth, whether or not they're a drunk doesn't matter. They could be a drug dealer. Sure, they may have a prior conviction that's going to come out. Maybe they don't have a prior conviction. They just have a reputation for being a drug dealer. Their reputation is not going to come in because they may not be the one being, tried for the offense. These are all important things. So don't let your opinion, your social opinion about a person, whether they're, a good or bad person, or they're drunk, or their status in society, deter you away from trying to gather this information. It's important information. They just need to be able to do two things. They need to be able to give a narrative and testify to that from personal knowledge. And when I say narrative, it just clearly communicate. They're not going to confuse the jury. They can just clearly communicate, and that's a very low standard. Very low standard, because we can have kids testify. Remember that kids are hard to give testimony. So think about that. Very low. As long as they can communicate back and forth, they're going to be fine. And to testify under oath. There's some procedural requirements, actually taking the oath. That's one of the procedural requirements. You sit there, you please state your name for the record. Do you swear to tell the truth, the whole truth, and nothing but the truth? Right? That's it. Boom. And then testify. The attorney will establish a baseline of facts by asking some baseline questions. Where were you here? Who were you with? What were you doing? Did you see this person? What happened next? Right? These are all things. And then you get to the money shot of, what you're looking for. The second thing is impeachment. These are, this idea is how you attack a witness. A witness is on the stand. They've been declared competent to testify, and they've given an oath. And they've given some really damaging evidence about something. And now you want to impeach them. Impeach them for what? Well, there's a lot of different things you can impeach them with. Generally speaking, you want to impeach their credibility. You want the jury to think nothing about what they just heard. You want them to be like, right now, here's what you're thinking. Oh my God, that's some serious smoking gun evidence. That's really damaging. Obviously, defendant did it. Well, as a defense attorney, you want to impeach that witness. And flip it, vice versa. The defense attorney has a witness on the stand. Oh my God, the defendant obviously did not do it. That's the effect of the witness. The prosecutor is going to want to impeach that defense's witness. How do we impeach? How? What are our methods? What does an attorney have in their pocket? Well, they can attack the bias or prejudice of the witness. Maybe the witness is the defendant's best friend, or the defendant's wife, or husband, or significant other. Right? Why would they testify against the defendant? They wouldn't. That's why we're going to testify. We're going to impeach them with their bias. So now the jury is going to be like, I don't know if I can really believe them. We can also testify. We can also impeach them regarding the prejudice of the defendant or the prosecution. Maybe the victim. Maybe if this defense witness has a particular prejudice against the victim, well, of course you're going to testify favorably because you don't like the victim. You would like to see the victim in more pain, actually. So those are two commonly done ways. Prior felony convictions. I talked about this briefly in the previous chapter, in chapter 5, with regard to character evidence and using prior felony convictions to impeach the credibility for truthfulness. It's really just a form of character evidence, because we're going to say because you committed this prior crime, for some reason, you can't tell the truth. That's the character inference being drawn. That's a circumstantial situation using testimonial, actually using real evidence, because usually they produce a certified copy of the conviction. You just need a custodian who keeps that record on file to testify to it, but they're not testifying to the conviction. The conviction is going to testify for itself. It's a self-authenticating document, which we'll talk about later. But nonetheless, it's circumstantial and it's character, but it's one of the ways we impeach people, especially witnesses. Usually not the defendant, because the defendant usually is not going to take the stand. And if that's the case, we got some special rules if the defendant takes the stand and whether or not we use their prior convictions. Here we're just talking about a general fact witness, either for the prosecution or the defense. They're sitting on the stand, they're testifying to some fact, and the cross-examiner, the opposite party, the adverse party, they've got a certified copy of that prior conviction, and they're going to introduce it into evidence. They're going to get the witness on the stand to testify about that prior conviction, what it was, how long it was ago, etc., etc. And the jury's going to get to hear that. And what they're going to do is now they're going to take that evidence they just heard from the witness, and they're going to reevaluate whether or not it's a 10 or it's a 1, or if it's a 2 or it's a 7. Do they slide it up? Do they slide it down? That's what they're going to testify to. Another way they do it, attack the senses, right? The book says inability. I'm going to say attack all the senses: sight, smell, hearing, touch. I'm going to attack it all, right? Because whatever sense was used by the witness on the stand, whatever sense was used to testify because that's part of personal knowledge. I have personal knowledge if I touched it. I have personal knowledge if I heard it. I have personal knowledge if I saw it. I have personal knowledge if I heard it. I have personal knowledge if I tasted it. I'm going to attack those senses. How do you attack them? Well, sight is one of the easiest ones. Well, you wear glasses, don't you? Correct. And you weren't wearing your glasses the day of. Correct. And how far away were you? 100 feet? And didn't you just testify earlier that you can't see more than 50 feet away unless you have glasses on? No further questions, Your Honor. Right? That's attacking the sight sense. When you talk about hearing, same thing, How far away were you? You have a hearing aid? And didn't you just testify that you can't, hear within a certain distance, which would mean you need your hearing aid, right? So now the jury's going to sit there and they're going to hear that and they're going to be like, wow, okay, well, we originally signed this fact witness 6 or 7 category in credibility, but now we're going to move it down to maybe 4 or 5. And not that believable anymore because, your senses, the things that you use to testify personal knowledge about are questionable at best. The next thing that we have in the pocket, if my witness, so we've actually gone back and forth here. I'll show you the timeline, right? Direct examination. Witness testifies to A, B, and C, and it's really damaging evidence. Then the defense comes by, the adverse party. It could actually, the prosecutor could have made this really damaging evidence, or the defense could have. Whoever the adverse party is going to cross-examine. Usually on cross-examination, they're going to try to impeach that witness. They're going to find some way to impeach that witness. That's really the only purpose for cross-examination, is to impeach them. Obviously, the person who submitted that evidence is not going to tell you everything that's bad about really what happened. Sometimes they do, and it's called removing the sting. But usually, we're going to have the adverse party allow them come in, ask leading questions, yes or no questions. Didn't you? You testified earlier too. Isn't it correct? Right? These type of questions to impeach the character, impeach the witness on the stand. All right. So when that happens, what do we got next? Well, the person who submitted the evidence, the side that submitted it, they get an opportunity to rehabilitate the witness on the stand, and this allows them to clarify some things. That's really all that it's about, or maybe to draw the jury's attention back to the real issue in the case. Yeah, you may have attacked my bias. That's true. I'm a biased witness. But bias has nothing to do with the fact that I actually saw, I saw the defendant defend themselves. I saw the defendant try to run away. That doesn't change the fact that what I saw is true. I may be biased, and that might be my best friend, but I saw it. That's all it is. We're going to try to remind the jury what's really important here. Another thing we can do, say we can't rehabilitate our witness. Maybe it was a prior felony conviction. That's really hard to rehabilitate the witness because, well, it's true. And sure, you can explain it, but it doesn't change the fact that you're a prior convicted felon. And for some people that are going to be on the jury, that's really important. And you want to try to distract them as much away. So what you do is you try to corroborate that fact witness's testimony on the stand by introducing another fact witness. This is when we got into what we talked about before about you have 15 different witnesses and you determine 3 of them are really good, but one of those 3 has a prior felony conviction, so you have another one to kind of balance that out, to kind of corroborate what this person with a prior conviction said. That's an example of that. You can corroborate that fact witness. That's not really a form of rehabilitation, but it usually has that effect. Another thing that your book talks about is memory failures. This is really important for a lot of criminal justice professionals because so many of you are going to be on the stand to testify. Take detailed notes. Sign and date your notes as well, because you're one day going to be asked to take the stand about something 6 months after, a year after, maybe 2 years after. Heck, it could be 15 years after, depending on the circumstance. If I file a motion for appropriate relief, I can file that really at any time. As long as I have a good reason for it, I can file that, and that could be 15 years later. You may be called to testify about that circumstance. And if you're on the stand and you're like, I have really good memory. You get on the stand, and then you start losing your memory. You're like, oh my goodness, I don't remember. There's a tool for that. Attorneys can get you we can refresh your recollection about the situation. We can say, Do you recall writing anything down? Yes, I do. Would it help your memory here today? Yes, it would. All right, well, I'm going to show this to the adverse party, and I'm going to give you this to refresh your recollection. You look over it, and then, I take it back. Has your memory been refreshed? Oh, yes, it has. And can you please elaborate again on the question, and then you answer the question. That's refreshing your recollection. And it's really important that you have something that's really good, because I don't want to have to resort to writing something down for you, or I don't want to have to resort to showing you a newspaper. I would like to refresh your recollection with what you actually wrote down the day of and you signed and dated. The other thing is that there's a hearsay exception to past recollection recorded. If I can get you to testify that, yes, I did I once knew about it, but I have forgotten it now, and when I have something that I wrote it down on at a time where my memory was fresh on it. I wrote it down, I signed and dated it, and I adopted it. Well, then I can get you to read that into evidence, and it can come in for the truth of the matter asserted. We'll go more into that later. But memory failures are a big deal, and as criminal justice professionals, you are very, very likely to encounter many memory failures. So sign and date and be detailed with your notes, so that you can help the attorney out who's going to be working on the case in some way and has hired you, or you work on the case in some way for the government to testify about those events and be a credible witness, and don't end up in those situations where we're going to attack your sentences. That's chapter 6. Again, this is about, the whole scene and A Few Good Men. We had the testimony of Jack Nicholson on the stand, and he was testifying. He had his competency established, right? He had personal knowledge. He had a duty to tell the truth. He recognized that, right? You didn't necessarily see that. And then we're going to not really go too much into the narration, because this is an adverse witness. Tom Cruise went directly into impeachment, because that's all he needed to do for his client. He needed to impeach Jack Nicholson. And how did he do that? He did that by attacking his prejudice, attacking his bias for the military. And in fact, showing that there was a direct order, right? And he just wanted the truth. That's what Tom Cruise wanted, right? He wanted to show that his clients were merely following an order. And he had to show that Jack Nicholson was the one that delivered that order. In order to do that, he had to attack his credibility. He had to impeach him, because he was thought of as a upstanding person who would not give this type of order. But he had to impeach him with prior inconsistent statements and bias and prejudice to get him to say you could not handle the truth. And then Jack Nicholson went on further to incriminate himself about whether or not he gave the order. That was all impeachment. There was no way to rehabilitate it, because that was the smoking gun evidence. That's very rare, but you couldn't rehabilitate Jack Nicholson when he clearly just said on the stand that, yes, I gave that order. And therefore, he's the one really guilty of the crimes being charged here today. So, with that being said, that's chapter 6. If you have any questions, please let me know. I look forward to seeing you for chapter 7.